Welcome everyone to our second 3CL seminar and our third 3CL event this term. It's great to see such a fantastic turnout on such a sunny day at Cambridge. And it's a very great pleasure for me introducing Professor Wolfgang Wurmnest. Wolfgang is currently a 3CL visitor at this faculty, and he is a full professor of law at the University of Hamburg just since last year. Before, he was a full professor at the University of Augsburg and Hanover. And before that, and this is where we met, Wolfgang, you had been a senior research fellow at the Max Planck Institute of Private International and Comparative Law in Hamburg, with which we have an exchange agreement, and we are very happy to have such close connections. Wolfgang Wurmnest was a visiting scholar in Foggia, Lyon, Hanoi, and now here. And his main fields of research are comparative and international tort and competition law. Today we'll see the competition law aspect. And Wolfgang, I'm very happy to have you here. We're very grateful. We're very much looking forward to your presentation. As always, we'll first have the presentation and then a discussion afterwards. Your topic is assessing antitrust damages in follow-on actions against cartels. Wolfgang, thank you very much for being here, and the floor is yours. Thank you.
Thank you very much for this kind introduction, and thank you to you all for having me here. I would like to present today on assessing antitrust damages in follow-on actions against cartel. Quite a long title. Well, what you know from the classes as far as I got, there is often competition law infringements in the newspaper. The newspaper cases are often cartels. For example, here an example. In 2016, the EU Commission fined truck producers nearly €3 billion as fines for participating in a cartel. And what you read in the newspaper, that is what we call public enforcement. You all know there are competition authorities. Every country that has a competition law has a competition authority. In the EU, it's the EU Commission plus the national authorities. Here is the Competition and Markets Authority, and all countries in the world with a proper competition law have those enforcement authorities. And they have very powerful enforcement tool. They can search premises and they can get all the data they need and all the evidence to prove an infringement. And this type of enforcement has a very, very long tradition here in the UK and also in Europe and the member states. There is, however, also a private law side to these cartels, and that is something more recent. So to take the truck cartels, there were various truck producers. I named here a couple, Daimler, Volvo, Renault, and Iveco, and they conspired. They conspired on list prices and others. And of course, you have customers who bought from them, and the question is then, do the customers have sustained a damage? Can they go after the cartel and can they claim damages from the cartel? So, and that is what we call private enforcement. Private enforcement is classic tort law, commercial litigation. Parties, private parties, buyers, sellers, they sue the infringers for damages, sometimes also injunctions, but usually damages. And they use what we call competition law as a sword. So you try to stop anti-competitive conduct by a sword. And actually, this is a rather new development here in the UK and also in the EU, unlike in the US, where that is has already a very long tradition. There are two types of actions. There's the so-called follow-on action, which is followed by after an infringement decision. So first, the authority conducts or searches some premises and finds out that there is an infringement, and the firms are fined, and after that follow on, there are these private enforcement claims. But you don't have to wait for the authority. You can also do it alone. Then we talk about standalone actions, but standalone actions against cartels are not existent, basically, because it's very difficult to prove that there's a conspiracy. So standalone actions are more against dominant firms who infringe the law. So I'm going to focus on this private side, and this is actually something which is on the rise. Here you have a slide with a graph made by Mr. Laborde. Monsieur Laborde is an economist who collects, with the help of many people in Europe, all the cases and always updates the statistics. And here you see 2021, we are around 300 cases for damages. And if you look in 1998, there were hardly any. And what made these cases going? Why do we have so many and we had so little earlier on? Well, there were two important things that happened. First, in 2001, the European Court of Justice handed down a case. Actually, it was a case here from the UK, and in which the court stated that private enforcement can make a significant contribution to the maintenance of effective competition. So the court said, look, we need public enforcement, yes, but also private enforcement can help to make competition law or the enforcement of competition law better. And that was an important judgment. At the same time, the EU Commission was thinking of modernizing the application of the law, trying to change the enforcement system, and also national legislatures started to ameliorate the law and do things better. And that's led to a steady increase in the numbers. And we also then, after years of discussion, we had a directive, a damages directive, in 2014, and that was transposed pre-Brexit. So all what's in the damages directive is still good law in the UK as so-called retained law. So you see now many European states plus the European Commission have laid the groundwork for these action for damages. So they are on the rise. We have quite a lot. But the question is, how much damages can you claim? And that is something which is even more recent. And you may wonder why, but I give you a quote here. For example, the Court of Appeal has stated in 2019 in an appeal in a competition case, in the Britnet case, to our surprise, the court stated, or the judges, we were told that this is the first case in which damages have been awarded by an English court or tribunal after a trial for anti-competitive cartel conduct which infringes Article 101 TFEU, that's the European Prohibition of Cartel. So these damages are referred as cartel damages for short. So you see in 2019 you had the first Court of Appeal case dealing with the amount of damages. Here in the UK, 2018 was the High Court deciding on that. And there's a similar situation in continental Europe. There was much litigation on jurisdiction and what are the requirements to bring damages. Often these claims are pooled. What do you have to do that? So we had a lot of cases, but we never went to the very end of it to see how much is the damage, how can we award damages. And why is this question so important that you dedicate now your lunch break to listen to me? Well, the key issues in follow-up actions are the following. You have to understand that if you're in the follow-on proceedings, you have help. Why do you have help? There was already an authority that decided on the case. So whether the infringement was there or not, that is nothing you litigate in a private follow-on action anymore. Why? The decisions of the authorities have a binding effect. So at least here in Europe and the UK. So that means you don't have to litigate whether there was infringement, what kind of market were affected. That's all in the decision, and that is binding for the follow-on litigation. So, in addition, the European Court of Justice has also clarified some issues which were disputed in the beginning. For example, who can sue? Who can sue? And the court said everybody. Anybody who is harmed can sue, so there are no restrictions. Unlike in tort law, where you have often restriction, if the damage is too remote, you don't allow the people to sue for it, and so on. And another important question is who is liable? As you can imagine, I just made these circles and said Volvo, Daimler, but these are large corporations and they have often many firms and they have daughter companies and so on. The question is, who can you sue? And also that was clarified by the European Court of Justice recently. You can go after what we call undertaking in European law. Okay, will explain that in his competition law class. So it's not necessarily the undertaking, the company that infringed the law, where the people sat and conspired about prices. Maybe you can also sue the mother company, which has more money, deeper pockets, and so on, and sits probably in a country better for you to sue in. So all that was clarified by the European Court of Justice, so that is also not a matter today for litigation or for much litigation. So the important points, what we litigate in these follow-on actions today are the questions of causation. When you buy from a cartel, was that within the cartel period or was it before or after? Then probably no damage. did the cartel cause a damage at all? And maybe it was passed on in the chain. And what is the amount of damages? So the last two questions, these are the important questions many courts in Europe and in the UK are dealing now with. So, and as I said, it's a very new thing, even in the UK, the first judgment, Court of Appeal level, 2019. That's not a long period. So now the question is, do cartels cause harm to consumers? When I talk about consumers, I mean everybody who buys or sells to a cartel, not consumer in the private law sense. So it can be firms too. But the competition lawyers talk always about consumers, so I take on this term. So now, do the cartels cause harm? You might be wondering, why is that a question? I mean, why do we prohibit that? I mean, and fine them so many million euros of damages, fine them so many million in a penalty. Well, you might laugh, but in the proceedings which we see today, that is always disputed. And the defendants often say, well, yeah, we tried to implement here a cartel, but we didn't manage, we didn't get there. It was all very complex, and there were price rises anyhow, so it's not our fault that the prices were sort of rising. So now, there are some economic studies. Of course, we have cartels since hundreds of years, and there are economists and lawyers who collect these evidence, and there's a big database by Connor and Lande, and there was an Auxera study commissioned by the EU Commission. And this studies looked at all the cartel evidence we had in the world, or at least in the Western world, from the last, I would say, 100 years or so. And then they came up with the following graph. They said, look, that's here, the overcharge, and this is the amount of overcharge. So you see there can be cases where you have no overcharge. It can be happen because there were anyhow things in the market that changed, so prices went up, or the cartel didn't work properly. You agreed, but nobody kept the agreement. So that can happen, but that is very rare. And you see in most cases you have at least some damages, some amount of overcharge here, up to 60–70%. So I think from this data, it's fair to say that in most cases, cartels do cause harm, and the damages directive therefore states a presumption of harm. So there is a presumption of harm, which of course is rebuttable. So in a trial, the defendant, the cartelist, can say, well, we had a special case, and there was no harm, and therefore no damage, and therefore you cannot claim any money from us. So harm caused by a cartel, that's a complex issue. I will focus on the most important harm, and that's the classic overcharge. So think of a producer cartel here, the truck producers. They conspire on prices, and they charge usually more than they would do if there wouldn't be this agreement, and therefore that is what we call overcharge, the money that was charged on top to the competitive price. So I will focus on that, and the question is now, how much is the overcharge? How do we quantify that? And that is it's not about the damage as such. That there is a damage is, I think, clear from the statistic in most cases. But the damage you just say it's more than zero. It's a little bit more 0 point whatever, but you don't know whether it's 5%, 10%, 20%. So that has to be assessed by the courts, and that is a very tricky thing, and courts are actually struggling to get the right figures. Why is that so? So looking first in the law and having a little comparative survey, some countries have looked at these statistics or at some other sources and have said, look, we introduce a presumption, a rebuttable presumption of overcharge. So the law says, for example, in Hungary or Latvia, 10% overcharge is presumed. In Romania, even 20%, quite a lot. But most countries have said, no, we cannot have that, no presumption. We have to see in each and individual case how are the circumstances of the case, and then presume this damage that is actually caused. So most countries have no help for the judges. They just say, please, the judges should somehow calculate the overcharge and then assess the damage. So why is this such a complex undertaking? Well, now we have to delve a little bit into economics. And the assessment is based on a hypothetical scenario. So because you know, and you can measure that somehow, how the prices were in the market. But then to assess what would be the damage, you have to make somehow a comparison between the competitive price, what would have happened if we had no cartel, and the prices charged by the cartel. And therefore, we need a hypothetical scenario. We need to know what would have been the price absent this infringement. So, and that is simply guesswork, so to say, because you cannot measure it by looking into the books. And not even the defendants often do not know that. It's not possible just because, just by looking into the books of the cartelists, you will not find out. Maybe they have neatly, maybe it was a German cartel, so they neatly wrote down everything, but you know it's illegal, and normally people don't do that, and try to get rid of the evidence. And even if it's a long cartel, you don't know how the competitive price would be evolving. You know, prices rise and all the time, or get changed all over the time, so it's very difficult. So, so you see, what's important to understand, also courts are learning that now, you cannot really measure the hypothetical development with precision, if you are honest. You cannot do that because it's an assessment, it's an estimation. So you need to estimate the damage, and the question is now how? How are courts approaching that? Because, as I said, you need to have this idea, how would be the prices absent the cartel, and then you look at the prices with the cartel, and the difference somehow, that's the overcharge, and that's what the damage is based on. So there are actually two ways, very simply, I mean, economics are very complex, I simplify here, but there are two ways how courts have approached this problem. The first group of courts have said, if you look into the European decisions, well, we try to gather as much, or at least a necessary amount of data in each individual case, and that is the classic civil procedure approach. So plaintiff and defendant present the evidence, often economic expert opinions. There are many economic consultancies out there, and you can go to them and say, look, we've got this problem here. Can you help us to assess the damage? And they say, sure, we can. We are as expensive as the lawyers, and we need the data. So bring us the data, and if not, we can collect it, and then we can try to look how we can put up some model to get the damage. So the problem is that you always have to get the data for each specific case. You know, it's not in the newspaper or some general statistics. You always have to adapt it to the case at hand. So, and based on that, actually, courts check the arguments and calculation presented by the experts, and then they determine how much is the damage, how much is the quantum. And actually, in some countries, for example, Germany, often after a third expert has actually went through all these material presented and said, okay, I think here it's not 0% as the defendant said, it's also not 30% as the plaintiff says, I think whatever 10% is the overcharge here. So you see a very complex litigation thing, especially when you have big cases involved. So the problem with that is that you don't often have sufficient data to do a very good economic assessment here. So another group of cases, actually, the court said, well, that is all very complex, and we cannot do it for this or the other reason. So our idea is to rely on the information in the infringement decision. I told you, you are in the follow-on trial stage. So there is an infringement decision telling you that there was a cartel and how it worked and so on. And the idea is look into that infringement decision. And if you take the information in there, how long did the cartel last? Only 1 month, then probably very unlikely that there's a damage. 10 years, then if you buy at the end of the cartel, it certainly worked. How much was the market coverage? Was it covering the entire market, 80–90% of the producers? Then it's a good chance for price increases. If you have a lot of outsiders, then of course you cannot increase the price so high, because then probably the supply or the demand will switch to these outsiders. So the idea is look at the infringement decision, and then you can somehow evaluate the overcharge, and then it's much easier to get a figure and to hand down your judgment. So now, looking at these two models, I want to explain why actually the second model was developed and what's the problem with the first model. Actually, both models are not perfect, and we have to find a way to deal with the complex issue. Well, if you ask an economist for the best way to measure cartel overcharge, he would probably point out to the so-called different indifferences model. That's how they call it, at least in Central or in continental European countries. What is that? Well, the idea is that is a very complex thing, but it's a very theoretically a very good thing to do, and probably you have a very good chance if you have all the data available to see what the overcharge is. So the idea is you look at the market which is cartelized, in my example the truck markets, and you see how the prices develop after the cartel, during the cartel, and before the cartel. So you need a lot of data. And then you compare the changes in price to a non-cartelized market in a different country, or maybe a different product, but which has is similar, and then you compare the price rises in both markets. Why the price rises? Well, as I said, prices are always going up and down. Simply because there was a price increase in the cartelized market doesn't mean that this is all due to the cartel. And then you compare, and you see in the non-cartelized market, maybe in a different country, there's a price increase of 3%, and in the cartelized market, there's a price increase of 20%. And you have 3% in one market price increase, 20% in the other market. Fine, there's a good chance that 17% is the overcharge. So that is the gold standard, I would say, in the economic model. The problem is it's hardly applicable in practice, and the courts cannot really do with that, because first, it's very difficult to get comparable markets. Of course, the market, there was a case in Spain where they said, you know, the Mexican market is fine, and then the court says, well, are you sure that the Mexican market is close to the Spanish market? Shouldn't we look in the US or some other countries? So very difficult to find a good market, and even if you have, you probably don't have the data to do that. So this gold standard is a textbook approach which is not really working in practice. So, therefore, in practice, what we see in courts, we have the so-called before and after model. So what you do, you only compare prices. You look what were the prices before, during and after the cartel, and then you try to figure out how the overcharge was and try to assess the damage. The problem with that is that cartels often are working very long periods, and if it's like more than 10 years old, normally you don't have data, because companies don't have to get all these material on stock. You can throw it after a while. Usually there's a rule in tax law how long you have to keep your information about certain transactions. So usually don't have the data, and the price levels can also distort the assessment. I want to give you a little example to explain that. That is a famous cartel in Germany, which was, The Economist did a very good statistic on that. You see here a cartel that was formed in January 1990, and it was here discovered, or somebody broke away from the cartel agreement in 2002, and then shortly thereafter, there was actually the German Competition Authority investigating and then finding all these producers of cement. Cement is a material you use usually in construction business. You know, you put in some water and it hardens. And that is a product which is sold basically all across the world. So, and we have a lot of cartels in that industry. And you see the prices were over the years increasing, and they were really going down dramatically after the end of the cartel. So now you can say, wonderful, you know, they go really down. That means they have a huge, wonderful overcharge, 20, 30% overcharge. But actually there was a price war going on after the end of the cartel. And probably if you have a price war, you're going below the competitive price. So applying the before and after model would probably overstate the damage. Because you go really low in a price war, you will go below what an average competitive price would be, and therefore you overstate it. But it can be also the other way around. For example, if you're a cartelist and you are detected, and then you sit and see, how should I change my pricing policy now? You would probably say, well, if I go down, then I face all these damages claims, so I don't go down, only a little. Yeah, I only go down a little and see whether my competitors, they're also not stupid, they will do the same. Yeah, so we only decrease a little bit. And then you have only very, very small amounts, and that would probably underestimate the amount of damage by the before and after approach. So you see these two examples I gave you show that these economic estimations, they are based on a lot of assumptions, and these assumptions are not something which is hard science. You know, and therefore, in the proceedings we see, it's very often, especially in the truck cases, that the defendant said 0% overcharge, no damage caused, and the plaintiff says 15 or 20% damage. So now, you see the economic model, what I call the economic model, measuring all that. It's complex, it works, but it's not perfect. Now, is the other model that was developed by some courts helping? So should we look at the infringement decision? Well, the point is that would be much easier to apply. It's faster, more cost effective, but it's not very reliable. Why? So far, we have no clear economic correlation between the certain factors of a cartel, how long was the duration, how much was the market coverage, and so on, and price increases. So we don't know exactly how that works. Maybe in future studies, economic studies will tell us that, but at the moment, we don't. So most economists, I would say, or probably not all, you never find all economists agreeing, same as all lawyers agree on something, you know, that doesn't happen. So most economists argue against that type of estimation, and I think they're right. We cannot only rely on that. So, but on the other hand, as the economic model, which I termed it here, has also problems, and often it cannot be done, maybe we have to somehow combine these two models to make a workable approach in practice, because the point is, the more complex you do the assessment, and the lack of data is there, of course, that plays in the hand of the defendant. But who caused this entire situation? Was it the plaintiff or the defendant? Well, it was the defendant forming the cartel. So I would say you must put the burden on him more than on the plaintiff. So in my eyes, we cannot solely rely on one model. We have to somehow combine those two. So, and how can we combine it? Well, there was actually a proposal recently by a German academic, Heike Schweizer, and she pointed out that actually what also the court had said before, that if you look at these studies I presented to you, the Auxera study, the meta study based on this on-Landi data, it says that the overcharge is often around 10 to 20% in 40% of cases or so. No harm cases have a very low probability, only 7% around, depending on the figures, and that is a little bit disputed, but you can say it's low. So this helps a court to structure the way to assess the damage, because what, depending of course on the procedural system in each state, which differs slightly, but what a judge can do when you come to the stage where you assess the damages, you can easily analyze the decision and make a rough estimation on the damage, because I think it has some argument that if there's a certain cartel structure, you can at least say, well, there was a good possibility to raise the price because the market actually helped that. And if you can raise prices, we know from economic theory, then you will do it. So that can at least helps you to get a first anchor, as we call it. You know, probably from behavioral law and economics, you need, when you estimate, a sort of anchor. Where do you start? Do you look more at 30%, at 20%, at 5%? It's like negotiating other things. You need an anchor to start with. So I think this infringement decision will give information as an anchor, because it tells us the cartelists had good chances to increase the price, and then we look at the average prices, and then we say, well, 15, 20% looks good. And then the judge can communicate this figure to the parties, and then it's up to the party that want to deviate from that. So if you want a higher amount or a lower amount, then you as a party have to explain to the judge why you think 15% is not correct here, why it's 0% or why it's 60%. So that is a way where you can somehow structure the analysis. At least as a start, it helps the judge to structure the evidence proceeding. And the question is, of course, what happens if there are not sufficient data? The economists say we cannot do the gold standard, nor the silver standard, and even the bronze standard is not really working here. What can you do? Will you say, okay, bad luck for the plaintiff? Or will you then try to estimate on this method, which is, of course, not perfect. And as I said, there's no clear economic correlation, but it gives you some indication at least. Then you would at least could award damage, at least to a certain extent, to the plaintiff. If you don't do it, you would then say to the plaintiff, sorry, you can't prove your damage, and you have to prove your damage in principle, so I dismiss your action. So, and if you only depends on economic data. So that is why I think we should combine the models, and we should not dismiss the model by looking at the infringement decision completely. Good, and this brings me to my conclusion. I hope I have shown that the assessment of cartel damage is a very, very complex endeavor, and the amount of damages can only be estimated and not calculated with precision. That's a very important message I want to bring around, and one day maybe one of you will become a competition judge, and if you hand down a judgment, don't worry, you will be criticized by economists, that is, and by lawyers too, that is okay. But you know, we have to translate economic finding into workable proceedings for judges, and of course you can always do more, but we shouldn't overburden the courts with that. So, in my point, and that is also what most economists say, there is no one, not only one gold standard model, so to speak, that can be applied, but there are many different ways to show how a cartel damages can be assessed, because otherwise you always have this data problem. You have not sufficient data, so if you have only one model, in many cases you can't apply it, so therefore you have to look. And this is also new for the judges, that there are different models how to prove the damage. So in my eyes, we need a pragmatic approach. A pragmatic approach must be followed, and courts must have some leeways with the estimation of damages, and otherwise effective enforcement of competition law is endangered, and that would not be good in my eyes. Okay, this brings me to the conclusion, and I thank you very much for listening to me, and I hope I could got you at least the basics why this is such a complex endeavor and why courts are litigating, or why at the moment there's so much litigation on the amount of damage and so less settlements, because it's not clear exactly how you do it, and if it's not clear, then you can't really settle, because the firms don't want to settle in a range that is very detrimental for them. Thank you so much.